I would like to welcome to the show Jenin Younes, litigation counsel at the New Civil Liberties Alliance. Welcome to Free the Economy, Jenin.
Thank you so much for having me.
So recently, the Supreme Court a few weeks back heard an oral argument in the case of Murthy versus Missouri, which addresses the content moderation policies of social media companies and whether the federal government influenced them in a way that would constitute a violation of the speech rights of their users in the First Amendment. Before we get into the merits and the underlying issues in the case, can you give us a quick outline of how the case was first brought and how it made its way to the High Court?
Sure. So it was initially brought by the attorneys general of Louisiana and Missouri on behalf of the citizens of their state. They asked some individual plaintiffs to join, Jay Bhattacharya, Martin Kulldorff, who are epidemiologists at Stanford and Harvard, respectively, a woman named Jill Hines, who runs like an health freedom organization, and Aaron Cariotti, a psychiatrist in California. Also Jim Hoft, although he's not represented by us. So we're representing the four private plaintiffs in the lawsuit. And they actually asked us because I had brought a similar lawsuit that was actually dismissed by pure coincidence the same day that this one was filed in the Western District of Louisiana. So they knew that I was interested in the subject matter.
And so this is about, like we said, federal government influence on social media companies, but specifically in this case about health information about sort of COVID-19 and government uh, government policy recommendations and the various people like the defendants here who took exception to those positions, to those recommendations.
Right. So our plaintiffs are all arguing that they were censored on COVID-related subject matter on social media, and ultimately that the government was responsible for that censorship. Jim Hoft, the fifth plaintiff, his subject matter is more about the election. So the lawsuit as a whole alleges that the government was involved in suppression of speech on a variety of subjects, but it's true that our plaintiffs are limited more to the sphere of COVID.
Right. And so the general dynamic here, which many of our listeners and viewers will probably be familiar with, is that various officials in the federal government have tried to get social media companies like Facebook and Twitter to take down information or to shadow ban users who posted material they objected to. As we said, particularly a lot of with a lot of these individuals when it happens to do with COVID-19 information, um, and that this didn't constitute direct government censorship, but what we've now started calling jawboning, with the dictionary definition of that is that it's an attempt to persuade or pressure someone using the force position of like official authority. Um, so the government didn't directly ban anyone, but they leaned on or threatened or intimidated or tried to get these private social media companies to do it on their behalf. So this, I'm sure, plenty of other people have made this connection as well. But this, having read about this recently, reminds me of the famous case of I think it's Norwood versus Harrison from the 70s, in which the Supreme Court said that the state cannot induce or encourage or promote private entities to do what is forbidden for the government itself to do. So you can't just deputize a private organization to do something that's unconstitutional, that would be unconstitutional for the government to do. And it seems like the sort of again quote jawboning here when federal government didn't like what people were saying about COVID-19 health information, and sort of leaning on the social media companies to shut down that dissent. Isn't that basically just the precedent in Norwood, the standard where they're trying to get a private company to do what they can't do themselves?
Exactly. And that's exactly the argument. So, I mean, if you think about it, there would be virtually or maybe literally no point to the Constitution if the government could just outsource the things it wasn't allowed to do directly to private industry. I mean, imagine if the government could just hire a private company to break into your home without a warrant, then there'd be no purpose in the Fourth Amendment. And so we're arguing that it's an analogous situation here. And a lot of people, I think, look at this, well, this is misinformation. We need to keep people safe from misinformation. What about the people who say the vaccine has a microchip and all of that? Our plaintiffs, and I would say especially Jay Bhattacharya and Martin Kulldorff, were top epidemiologists censored on the area of their expertise because they advocated for policies that differed from the government's, like they opposed lockdowns, mandates. They said, you know, the vaccine, that maybe children don't need the vaccine, naturally immune, that kind of thing. And when that sort of illustrates why we have a First Amendment, because the government has shown clearly, as happened here, that it can't be trusted to sort of draw the line between the microchip argument and people who just have dissenting opinions from the government. I mean, once you allow the government to censor, governments tend to use their power, use it for power.
Yeah, and I think the question of competing claims over COVID-19 health policy, which itself was a very divisive issue, has sort of colored the opinions of a lot of people on this case before they've maybe instead of really thinking about the underlying legal issues. So, if you think ivermectin is a great treatment for COVID, maybe you're automatically going to be opposed to the government's position, and then if vice versa, maybe you'd be more likely to look, to be in favor of it. But the real issue to me seems that the government, like you said, is that, being allowed to influence free speech in general, regardless of the topic, is the question is what we're worried about, and how much power, sort of, sub rosa behind the scenes power, it makes sense to allow the government to exert. A different administration or a future government agency could easily have taken the opposite side as the agencies did during COVID pandemic, and that it wouldn't really change the underlying issue of whether we should be allowing them to do what they did or not. Um, how do we balance our opinions about, the specifics of like the specific facts of the case with the sort of underlying constitutional issue here that's at stake?
Well, that's an interesting question. I mean, I guess my answer would be the government should always be out of the business of censoring or abridging speech. The First Amendment actually uses the term abridging. And people should remember, that, well, now it's President Biden, and it was the Biden administration mainly that was behind the censorship. But what if it's President Trump who's elected? If the Supreme Court says that the president can persuade or intimidate, coerce these companies into censoring material he doesn't like, maybe your views will be next to be censored. So it's really, I think it's an extremely important issue.
Yeah, and that said, that there's sort of a difference between the instant facts of this case and the sort of the deeper constitutional issue. I think if we do look at the specific results of suppressing speech, in the case of COVID-19 information and public health policy, and medical research, there seems to have been a significant downside to the government's actions, even if you're someone who thought the NIH and the CDC were kind of on the right side of the science. And I think this is a quote from John. I think you wrote last year about how even the National Institutes of Health recently acknowledged that public suspicions of scientific experts and levels of distrust in the government are increasing. So, could that be a reason going forward for government agencies to refrain from the sort of conduct that is at issue in Murphy versus Missouri, simply because there now seems to have been such a backlash where you have even fewer people believing federal government public health advice, precisely because they feel that there's coercion going on behind the scenes?
Of course. I mean, people are not as stupid, I think, as these agencies, as the people who work at these agencies think. I mean, a lot of people know what happened here, and they see that the government suppressed information, and you get suspicious. Well, why are they suppressing information? Why aren't they just telling us their side? The CDC has every right to go on social media and say, we think the vaccine is great, everyone should get it. And the people who are saying the vaccine has a microchip are wrong and it doesn't. That's, typically how we have dealt with problematic speech, is through counter speech. And that's what the First Amendment recognizes. And, censorship, in my opinion, too, and I think this was one of the rationales underlying the adoption of the First Amendment. Censorship just drives it under, like, the ideas underground. It doesn't make them go away. So, the people who got kicked off of Twitter for saying the vaccine has a microchip go to Gab, where they're in more of an echo chamber, and they're less likely to confront people saying, no, actually, it doesn't, and here's why.
Yeah, and you sort of alluded to this, but I think one of the big angles here that has so many people concerned is not even that the federal government is expressing an information or an opinion about this, alleged misinformation, but that it did so basically secretly, and that, if federal public health officials had wanted to do more of this, you know, uh, messaging advice for social media companies, uh, they could have, issued public recommendations or held a press conference and said, you know, our people have seen this stuff on social media and we would like to like tell you why we disagree. Um, but that's, I mean, maybe they did some of that, but they also did this other stuff, this sort of sneaky behind the scenes stuff. And not everyone would have, not everyone obviously liked the public messaging that they did do, but at least they would have like, known about it. And users on social media could have, pushed back to the companies themselves if they said, "Oh, we think the CDC is trying to, tell you to shut us down." There could have been more of a conversation about that. Uh, how different would it have been, do you think, if there had been sort of the public version of jawboning where, the, White House press secretary was, yelling at, Twitter and Facebook, as opposed to sort of uh, secretly having meetings with them that no one knew about.
Well, that's an excellent question, because some of both was going on. So you probably know that, but the press secretary did get up on several occasions and said, these companies are responsible for the spread of misinformation. People are dying, so they're not getting the vaccine because of this misinformation. They'd better do something about it. We're having meetings with them. We're flagging posts, which was how people like me knew there was something going on. So, and then it turned out when we got discovery in our case that it was kind of even much more than we thought it was. I mean, just so far, as far as we know, dozens of federal officials, agents, a number of agencies, I think at least 12 or 13 involved in this enterprise, all going on behind closed doors, both sort of encouraging, berating, coercing, persuading the companies to censor anything that departed from the government's messaging. And there was a variety of, I mean, it wasn't all one thing, right? So I would say the CDC's contact with the social media companies looked more cooperative than the White House's. The White House was constantly emailing and saying things like, if you don't do something about this, we're going to have to look at our options and consider what to do. The CDC was the companies would reach out and say, what do you think can you tell us which posts to flag, this type of post, that type of post? And we're arguing it's all a First Amendment violation because the text of the First Amendment prohibits the government or forbids the government from abridging the freedom of speech. It doesn't say, coercing or prohibiting, to be contrasted with the religious freedom, which uses the term prohibiting and was clearly a conscious choice when you look at the evolution of the text there. So we're arguing that any action take to sort of diminish or reduce or censor is a First Amendment violation. So getting back to the beginning of your question, I realized I went off a little bit there. It would be hard to make a case, I think, just based on the public statements. I do think one could argue that those are First Amendment violative. If that was all that was happening, I think you might have more trouble showing like there was an injury and various aspects you'd have to prove to make a case. But here it was really what was going on behind closed doors that I think makes the case.
Well, yeah, and I wonder if this is not a case of federal officials over the years becoming sort of more innovative, right, in trying to accomplish things via methods that are more difficult to challenge. Because if you have people who know about how like rules are made with federal agencies, if you have a rule that's a formal rule, it has to go through the Administrative Procedure Act procedures, and it has to be posted and commented on, and then everyone knows that it's going through the process, and they can comment on it, and then if they disagree with it, they can sort of challenge it in court. There's some high-profile recent regulations that are being challenged by multiple people in courts now. But of course, if it's not a rule that's published in the Federal Register, if it's just an email or a conversation, then especially one that's not public, it's not published anywhere, then it becomes a lot harder to push back on. And my colleague Wayne Cruz, a lot of people know about his work about regulation. He estimating costs, but also what he's been writing about in recent years, what he calls about the dark matter of regulation, right? The analogy to astronomy, where there's all this stuff that's out there in the universe, but we don't really know about it because it doesn't emit light. And so there's sort of the equivalent in federal regulation and bureaucracy where the government is trying to accomplish something and they're trying to use some kind of lever to get a private entity out there to do what they want. But it's so squishy and so poorly defined that the question is, can you even sue someone over this? And I guess that's what in case what this case is in part going to answer. If a federal agency, if someone in the White House sends someone an email saying, "Oh boy, you really better think about taking care of this problem, or we'll have to look at our options," is that an implied threat? Is that government force, or is it just, "Oh, well, that was just an email. That doesn't matter. It's not important."
Yeah, I mean, it's interesting because obviously if they published, the CDC had a regulation saying companies will be fined X amount of money if they don't remove vaccine misinformation, anybody could sue and, win. It'd be pretty obvious First Amendment problem. But here, as you note, there is this sort of squishiness to it. I can't think of a better word. But ironically, it's worse because nobody knew it was going on. It's like the secret operation. And I think there was a reason. They knew they couldn't do it out in the open. Um, I, of course, the problem you're pointing to is one of the things the court is going to be looking at and trying to figure out the line. I mean, at what point it just is the government just stating its own opinion, which they're certainly allowed to do, and we're not contesting that, versus but committing a First Amendment violation. And I think the line is when the government is the purpose of their speech is to try to accomplish the censorship of others. That is a First Amendment problem, and that's what we've been arguing. And here we also have proof that the companies did change their policies and escalate enforcement of their policies. The emails say that, you have this guy, Rob Flaherty at the White House, emailing and saying, we want you to get rid of more vaccine misinformation. And then they email 2 days later and say, okay, here are new policies. We're removing borderline content, which, by the way, is like true content that's inconvenient for the administration. So like shows true accounts of vaccine injuries that might cause people to not want to get the vaccine, that kind of thing. Yeah.
And this is a question that has come up in some other jurisprudence about social media platforms and about governments like states, for example, that have tried to put forward regulation of social media in other ways, not necessarily in the sort of misinformation area. That the argument is there's sort of, well, there's three main actors here, right? There's the government, whether it's the federal government or the state government, and then there's the platform, and then there's the users. And the question is, whose speech is at issue here? So in some of these other cases, the argument has been that it's the platform, it's the company's free speech that's being abridged because they don't because the stricter the government regulations are, the less they get to decide what rules to put out, what standards to have, what to allow and what not to allow. And so the idea is that they should have as a company have the freedom to make whatever rules they want for their platform. But in this case, it seems much more the case that it's not the essential First Amendment claim is about the individual users, not necessarily the platforms. But is it both really?
It's really about the users, not the platforms. I mean, I believe the platforms could bring their own case if they wanted to and say that the government coerced us or, persuaded us to do this and it was unconstitutional. But here it's really about the users, it's the third parties. And so one of the analogies that keeps coming up and came up at the Supreme Court arguments a few weeks ago is, well, government officials call newspapers all the time and say, can you not publish that story? It's in the, interest of national security that you don't. And the paper says, okay, fine, we'll hold off on it or we won't publish it. And nobody would say that's a First Amendment violation. first of all, I mean, I'm not sure I would say that's not a First Amendment violation, but it's sort of depending on various factors. But there is a major difference in that there it's the paper's own speech. So the government is engaging with them, and they're making the decision about whether or not to withhold their own speech. Whereas here, there's a user who has no idea this is going on and is having their speech censored. So, in fact, one of our plaintiffs said, I would love it if the government called me and said, Dr. Kuhldorff, can you please take down that post? I'd love to have a conversation about that. But instead, what they're doing is getting the companies to do it in secret.
Yeah, and like you said with this, I assume this was the emails that are generated in Discovery, where you see some of these social media executives actually being, very accommodating, more accommodating than maybe a lot of us as users would be comfortable with. Um, which is, precisely the problem, which is the companies themselves have a very strong incentive to respond positively to job voting because they're regulated companies, and that, there's a reason why this works and why they thought it would, why the White House and other people thought it would work, is because they're afraid of the legal discretion that various regulatory agencies have over them, and that there are consequences, whether they would be legally legitimate or not, that they expect that they could expect in the future if they were to, like, strong arm the White House and say, get off our lawn, we're not listening to you, um, and that itself would have been, who knows, years long uh, litigation involved, right? If they had sort of told the White House to get lost, and then the White House, went forward with some executive initiative by under the president's authority, um, that would be to their disadvantage, and they thought it was illegitimate. Well, that's years in legal costs challenging whether
Right.
that would uh, could be overturned or not. So, anytime you've got this two-level problem, which is, a platform has its users, but any of these other companies out there in the U.S. economy have their consumers and their workers that might be disadvantaged by, um, illegitimate regulatory initiatives. Um, Sometimes it's actually really easy for the big corporations to sell out their users or their customers or their workers to stuff that isn't really legitimate, but it's just kind of easy for them to say yes.
Right. I mean, and that's one of our major arguments here is that even when it looked like a cooperative partnership, CDC and Facebook exchanging friendly emails about what constitutes misinformation, and sometimes Facebook even asking for advice, like, do you think this is misinformation? Should we take this down? But the government had made clear what they wanted the companies to do. There were explicit threats, such as looking at ways to revoke Section 230, which the companies, it's their lifeline. Without Section 230, they can be held liable for what people post on their platforms, which would completely change the nature of social media. They'd have to, monitor every post, or I don't even know how it would work. And then, they talked about antitrust laws and potentially made sort of vague references to even criminal liability to people's deaths from, not taking the vaccine or whatever. So against that backdrop, I think it's hard to argue this is just even the apparently consensual exchanges were actually the result of a truly consensual relationship. And then you just look at the power dynamic of the U.S. government. No matter how much money these corporations have, they're nothing compared to the government.
Well, yeah, and I wonder for our listeners who were not listening in to the oral argument before the Supreme Court, a specialist interest, even for nerdy people. Um, what kind of questions were the justices asking, that everyone tries to sort of read the tea leaves based on their questions about what they think, how they might be inclined to eventually uh, come down in their decision. Um, what was the questioning like, and how did you get any sort of feel on where the majority was trending on some of these, like, major elements of the case?
I don't like to make predictions with that caveat. There were a couple main themes. One was the what about the dangerous misinformation? So like Jackson Brown, sorry, asked, well, what if somebody was posting like a challenge to teens to jump out of windows, and the higher you jump, the more points you get or whatever. Well, first of all, I don't know if I'd call that misinformation. It's stupid, but and so what we used to do, people have always said stupid things, and or dared people to do things. What we've done is counter that and say, no, don't do that. And I think, frankly, most people know not to jump out of windows. Even teenagers know that. So most people have the common sense to just not do that. But there, you know, censoring is simply not how you deal with problematic speech, as we discussed earlier. So that was one topic. And then another was, what's the line between persuasion and coercion? So at what point, which I think is the wrong question for the reasons we discussed, I don't think the government should be able to persuade companies to take down speech. They can persuade them to post the CDC's own information, for instance, but the government shouldn't be in the business of abridging speech or censoring speech. So that makes me a little nervous that they're going to set the standard at coercion and say it's a First Amendment violation if the government, accomplishes this by strong-arming the companies through threats of regulation or whatever. But it's totally fine for the government to have, conversations, even heated ones, and try to get them to do it on their own, and by to be good citizens or whatever. So that was the other theme. Alito, Gorsuch, and Thomas, we figured would be on our side because they dissented from the stay. So the court, when it decided to take the case, stayed the court below the Fifth Circuit's injunction, meaning it didn't have effect while this is pending. So 6 of the judges agreed to that without any opinion at all. 3 of the justices dissented very passionately and said this is a terrible First Amendment violation, and the court was just going to allow this to continue for 6 months or as long as it takes for the case to resolve. So we knew that we'd have 3 sort of on our side, and then 3 against the liberal judges, Kagan, Sotomayor, and Jackson Brown. And then the 3 swing votes are Barrett, Comey Barrett, Roberts, and Kavanaugh. And I didn't really get a great read on them. Comey Barrett asked an interesting question. What if the companies during COVID said, this is a once-in-a-lifetime pandemic. We're just going to turn over our content moderation to the government. Would that be allowed? And she asked it of the government attorney, and he actually said no, which I thought was a kind of good sign, because she was clearly recognizing that even if the companies are acting voluntarily, the government can't be controlling their content moderation decisions.
Well, yeah, and that even if the question, like you said, is comes down to being between persuasion and outright coercion, like we said before, the federal government is not just an ordinary voice in public debate, right? So my premise in a lot of these things, whether it's this case or it's what happened back in the Obama era, and what we called Operation Choke Point, where banking regulators were pressuring banks to close down accounts for sort of controversial businesses, that a suggestion from the government is not just a suggestion, right? It's a kind of like mafia, like, oh, nice business you got there. It'd be a shame if something happened to it. And even when it is not outright coercive, there's always an implied threat of force, or they wouldn't be asking you in the first place.
Right.
So I at least will be interested to see how in any final opinion, hopefully majority opinion will sort of take that up and at least acknowledge that, if not make it the centerpiece of the case, to say that, as some people I think have been either naively or maybe not in good faith, making the suggestion, saying, oh, well, this was just a suggestion from the government, so you can't consider that a use of force.
Yeah, I mean, that's also ridiculous when, we have a 20,000 page record in this case. And I think part of the problem, and maybe why some of the justices didn't quite get it, is that you really have to be kind of steeped in it. I mean, I've been reading these emails for 2 years, and there's to an extent, it is about the volume. There were just so many of these requests. They were constant. They were insistent. This wasn't one email saying stop vaccine misinformation or we're gonna find a way to revoke Section 230. It was relentless, and I think that is part of it. Although there were some emails that were just so coercive, there might be an argument that on their own they could be a First Amendment violation. But I think that's why higher courts defer to the trial court too, is that the trial court has had the opportunity to look at the record very carefully, and he made this assessment and found that the companies were acting under pressure from the government.
Yeah, and I mean the details of how Section 230 of the Communications Decency Act, all the way back from the 1990s, uh, uh, affects this as sort of a whole nother topic. But I think it's especially interesting since I've heard plenty of other people make this point, which is that that's a section of U.S. code that was a law that was passed by Congress. How the White House thought they were going to sort of just get rid of it on their own seems questionable in and of itself. I mean, if the argument was like, oh well, we'll go to Congress and persuade them to amend federal law to like change Section 230 for us, well, that would be a huge, major change in public policy. It would be a whole debate. That would be something that would take months. I would assume if it ever happened at all. Um, Certainly not something that the White House on their own could change, right? Even if they were extremely angry and they thought Facebook and Twitter were doing dangerous, scary stuff, that's literally not something they could have done on their own, which is change the protections of Section 230.
Yeah, that's true. But I think the theory is that the White House has quite a bit of influence on Congress. And frankly, there were members of Congress also making these threats. So I think that's part of the argument. And then we know, well, I cited some of the earlier emails where the companies said, we're changing our policies, we're going to start suppressing borderline content. But we actually have quite clear evidence that the companies did change their policies because of the administration. And that, unfortunately, some of this evidence came out after we filed the suit, so it didn't make it into the record. Through the Facebook files by the House Judiciary Committee's Weaponization of Government Subcommittee investigation. And there, a bunch of internal meta emails came out. And one of them, for instance, were two Facebook executives emailing, and one says, can you remind me why we censored the lab leak theory? And the other one says, it's because we were under pressure from the White House. We shouldn't have done it. That's a pretty clear admission that the companies were responding to the administration.
All right. So what's the prognosis now for the case? We had oral argument a few weeks ago, and then presumably it'll be a while till we see a decision.
I think June, because it's the end of the term, and it's a preliminary injunction motion, so it's not a full lawsuit. It's an emergency motion, basically saying that the plaintiff's First Amendment rights are being violated, and this is an emergency, and so it needs to be decided immediately. So I don't think it'll take that long.
All right. Well, we will definitely stay tuned. Thank you so much for joining us. And before we go, where should people find you online, information about the case? Where should they be looking?
Well, I'm on Twitter, and I tweet whenever there's a big development. It's at Jenin Younes, JeninYounesESQ. And then our organization is the New Civil Liberties Alliance. We also post any updates on there. It's nclalegal.org.
All right. Excellent. Thank you so much.
Thanks so much for having me.